All rise. Superior Court of Fulton County, Atlanta Judicial Circuit is now in session. Honorable Judge Jerry Baxter is presiding. Court will now come to order.
Everybody have a seat. All right, the state have anything to say?
Good morning, Your Honor. Yes, Ms. Willis, on behalf of the state of Georgia. Yesterday, as directed by the court, the state did meet with 9 of the 10 defense attorneys.
All right, we apologize. We're working on clarifying that signal for you. You're just joining us here. You're inside the courtroom now for as the sentencing continues in the APS test cheating trial. You're watching live coverage of this on Fox 5 Live, and we are still kind of getting our equipment in order there in the courtroom, so we will resume this signal here momentarily just as soon as it is ready. But we do have a new report just in from Angelique Proctor on the scene, who tells us that Defendant Donald Bullock's attorney, lawyer Harold Taylor, says they will likely take the deal that's being offered this morning. We do know at this point that several have said no to the possible deal. This is what's being reported there on the scene. That's Sharon Davis Williams, Angela Williamson, Diane Buckner-Webb, and Teresa Copeland are all saying no to the deal being offered right now. At least that was the latest word from outside the courtroom this morning, just before the court resumed, that you saw taking place underway. So the order yesterday, as we left the situation, was for the defense attorneys to meet with the district attorney to try and work out some type of plea arrangement. If they were not open to accepting that deal, then the judge was going to continue sentencing this morning. And that's where we are at this particular time, awaiting to see if some of the defendants did elect to choose the deal or if they are going to be sentenced in court by the judge. So we are working right now to restore our signal live from the scene. As soon as we have that, of course, we will bring it to you. Stay here momentarily with us as we work to get that signal reestablished. You're watching live coverage on Fox 5 Live. Stay with us.
I'll let you and your client, just speak regarding.
Your Honor, we did meet yesterday with the district attorney, and I've had several discussions with both my client and his family. This is a joint decision that we have made considering several factors. Obviously, we looked at first the political climate right now. We looked at the economic situation, understanding obviously that on an appeal it's going to be very expensive and relatively time consuming. We looked at what we call the family considerations. That is that Mr. Bullock has 2 children, both in college. He has a wife to support.
Is he claiming responsibility or not?
He is claiming responsibility.
I mean, he's going to need to tell me what he did. He's going to have to tell me, because I heard what he did, and I believe that those people told what he did, and he's going to need to fess up. And if he doesn't, then y'all can just go sit over there, and we'll go on.
Your Honor, may I finish?
I'm just telling you, giving me all these considerations. I'm just telling you, I don't want to waste time if he's not going to bare his soul here about what he did. And if he does, I'm going to grant him mercy.
We have entered into a negotiated deal, Your Honor, and we are going to follow that. I was just trying to explain to you all the considerations there. Mr. Bullock is willing to accept the responsibility, and at this point I'll let him go ahead and first do his apology.
I, Donald Bullock, do hereby sincerely apologize to the students, my fellow staff members, parents, and the Atlanta public school system, as well as the greater metropolitan Atlanta community for my involvement in the 2009 CRC administration resulted in cheating or other dysfunctional acts. I also apologize to the court and to its officers for the things that happened during the 2009 CRC administration, which I was a part, and acknowledge that it has caused a great use of resources and expenditures to resolve these issues. I hear.
Go ahead. No, you accept the responsibility.
I accept the responsibility. I accept the responsibility that I was convicted of the following crimes by a jury of my peers, and I am in fact guilty of the following things. Count 1, violation of Jury Racketeering Influence Act. Count 24, false statements and writings. Count 25, false statements and writings. And count 26, false statements and writings. I further state that I will waive all appellate future actions as conditions on court sentencing me on this negotiable deal.
All right.
Thank you, Your Honor.
Your Honor, and for purposes of the record, the recommendation, and as it relates to Mr. Bullock, is 5 years of probation on RICO, with 6 months of weekends to serve in the county jail, a $5,000 fine to be paid after that's 6 months to start being paid, 1,500 hours of community service. Those community service hours are to be done either in the jail to help inmates with GED or other educational needs. Also, our community leaders have been so gracious that they are going to assist us in creating a redemption program that will directly target the children affected, and he will agree to do part of these hours to serve the community that was harmed. That is our recommendation in relationship to Mr. Bullock.
That was acceptable, Your Honor, and we also had asked, because of the fact that he does have a son that will be graduating from college at the end of the week.
He'll be able to go see his children graduate.
Right, and we had spoken yesterday evening, and we said that he should not even begin until after that because it is coming so soon, and so he will not begin until May with those weekends.
All right. All right, I accept. Well, anyway, I sentence you to 5 years probation on count 1, 6 months of weekends in jail, $5,000 fine, 1,500 hours of community service, and there's
He should
ano-
be sentenced under the first offender as well for accepting this responsibility.
and there's another count, is that a 5-year count?
Yeah, yes, he has 3 more counts, actually, Your Honor. And we would ask that each of those just be 5 years of probation to run concurrent. His 3 other counts are count 24, false statements in writing, count 25, false statements in writing, and count 26, false statements in writing. The jury found him guilty of all of those counts.
Okay, 5 years probation to run concurrent. You understand the first offender, Mr. Bullock, I don't think you're gonna get in trouble again, but if you do get in trouble while you're under this sentence, they can bring you back here and I can sentence you to 20 years in jail. I don't think that you're gonna be in trouble. I hope that you're able to help some people, and I think you will. I think you will. In jail, in the schools, wherever they send you, and are y'all gonna have an auditor audit all this stuff?
Yes, the DA's office will be actively involved, but we've had so many community leaders, the Reverend Burley and others that are willing to assist us in this program, and we're very gracious to them.
Okay, Mr. Bullock.
And Your Honor, just for the record, I misspoke. Count 26 was a false swearing, and I believe I said false statements in writing. I just want to make sure the record's
Okay.
clear.
Thank you for accepting responsibility and at least relieving me of a harsh sentence for you. So anyway, good luck. And anyway, the probation gonna talk to him this morning?
Yes.
Okay. All right, let's proceed.
Your Honor, we would just ask for purposes of the record, we don't believe anyone else is entering, but if you would mark a blank one of these forms as Court Exhibit 30, we just want it to be part of the record, and we are ready to proceed. Other than that, we would ask that this be marked as Court Exhibit 30.
All right.
Yes?
What is that?
That court exhibit 29. Oh, okay.
Okay, are y'all gonna present some evidence?
Yes.
Judge, I'm sorry, on behalf of Dana Evans, I would object to any evidence presented in aggravation. We have not been provided with notice under 1716-4A5.
I think they're just gonna have people talk.
Yes, it's impact.
I understand we're entitled under the statute to 10 days prior to trial or at least at the beginning of trial with notice of any evidence in aggravation of punishment. I assume that's what this is.
It's victim impact statements.
She just said it was evidence in aggravation.
I'm joining that.
Okay, well, it's impact statements, which is different. So
Right.
go ahead.
Yes, and the state would start by calling Special Agent Eugene Howard.
Your Honor, if you could just make that a blanket objection, please, for, I assume all this.
How is Agent Howard impacted by this? He's not a victim.
I don't know. Mr. Rucker, I don't know.
Yeah, well, as the court is aware, Judge, the investigation of this case was particularly unusual and very difficult. And the testimony during trial has been that the agents were stonewalled at every turn by these defendants.
And if that's not our,
Okay, let's just skip him. I heard it. I saw it. I lived it.
Okay.
Okay?
Your Honor, actually, I guess we'll change the position. And I don't think we'll call anyone. I think
Okay.
we'll just
You don't
proceed
need
right
to
on
call
sentencing. Okay.
How would you like us to proceed in terms of recommendation?
Well, do you have a recommendation?
We do.
Okay.
They're different for each individual.
All right. Tell me your recommendation.
Your Honor, for the SRT levels, which of course will be Defendant Michael Pitts, Defendant Tamara Cotman, and Defendant Sharon Davis Williams. For Michael Pitts, As you know, he was convicted of 2 counts. The first was the RICO count. The second was the influencing witnesses. The state would recommend 5 years to serve 3 on count 1. On the influencing witnesses, we would ask for 5 years of probation to run concurrent with count 1. On Tamara Cotman and Sharon Davis Williams, we would ask for 5 years to serve 3 on the RICO count they were convicted of. Proceeding on, Dana Evans was convicted of 2 counts.
All right.
Dana Evans was convicted of count 1, RICO, and count 14, false statements and writings. For the count number 1, we're asking for 5 years to serve 2. On the count 14, we are simply asking that it is 5 years suspended. For Tabika Jordan, who was a vice principal at Deerwood, which Your Honor, I'm sure will remember kind of started the investigation in this case, the state is recommending on that 1 count 5 years to serve 2. On Angela Williamson, a 4th grade teacher at Dobbs Elementary School, convicted of all 5 counts she was charged of. Count 1, RICO. Count 9, false statements and writings. Count 15, false statements and writings. Count 16, false swearing. And count 17, false swearings. The state is asking for 5 years to serve 2. On Theresia Copeland, a testing coordinator at Benteen Elementary School. She was found guilty of count 1, RICO, and count 29, false statements and writings. The state is asking that on count 1, she be sentenced to 5 years to serve 1, and that on count 29, she be sentenced to 5 years suspended. To Pamela Cleveland, who was convicted of 3 counts in this indictment, all 3 she was indicted of. Count 1, RICO, count 18, false statements and writings, and count 20, false statements and writings. The state is asking that she is sentenced to 5 years to serve 1, and that on counts 18 and 20, she be sentenced to 5 years suspended. To Diane Buckner Webb, she was convicted of her 3 counts as well. Count 1, RICO, count 18, false statements and writing, and count 19, false statements and writings. We are asking that she be sentenced to 5 years to serve 1, and that on counts 18 and 19, she be sentenced to 5 years suspended. And the state's only statement would ask that we, like you, heard many moving statements yesterday of family members that were affected. We would just like you to consider all the children in Atlanta that were affected for so many years.
All right. Let's see. Bring up Ms. Sharon Davis Williams.
Y'all, can I just bring up one point before it begins? This morning, I received a memo from the state, and it's my understanding they're requesting that the court not sentence the defendants under the conspiracy statute the court agreed to do yesterday, but rather the sentence under the RICO statute. So I think that before the court enters a sentence, we need to get clear which statute they'll be sentenced under.
Okay, well, I overrule your objection to this. I think the state is correct, and, you know, you're going to have this on appeal. You're a brilliant appellate lawyer and, you know, one of the strike that. Let's go ahead, Ms.
Yeah,
Sharon.
Could I just cite to the court a couple of cases? I don't think it's in dispute that these defendants could be sentenced under either statute based on the verdict form, since they were convicted of conspiracy to commit a RICO. And under Georgia law, where a defendant could be punished under two statutes, a defendant should be punished under the statute which would impose the lesser penalty. And I'll cite to the court Langston versus the state, 258 Georgia 188. It's a 1988 case. I would also cite to the court Chandler versus the state, 257 Georgia 775. It's a 1988 case, where any uncertainty exists as to which penal clause applies. The accused is entitled to have the lesser of the two penalties administered. So under Georgia law, where it is ambiguous, or there are two competing statutes, the defendants are entitled to be sentenced under the statute which would impose the lesser penalty. And what I would ask, we just received that this morning, I would ask that the court take a look at that and maybe give us an opportunity to argue that more fully before imposing a sentence, because if it's...
No, the sentence is gonna happen today. If it's an error, you can take it up.
Well, I'm not suggesting that you don't do it today, Your Honor. The only suggestion I'm making is that we get correct which statute they should be sentenced under. Because if the court would take a look at the verdict form, if the court would mind taking a look at this, the verdict form clearly states conspiracy to violate. If I could just hand this up. The verdict form clearly states conspiracy. The RICO statute used the word conspire, but this statute, this verdict form, and the statute that I'm citing clearly talks about a conspiracy to commit a felony. So we have two competing statutes. I would only ask the court to take a look at this before imposing a sentence. That's my only request.
I've looked at it.
Very well.
Go ahead.
Do you need a response from the state?
Yeah, go ahead.
Okay, just for the record, Your Honor, there's absolutely no confusion other than that manufactured by Mr. Davis. The indictment makes no reference to 1648, which is the general conspiracy statute. It refers only to 1614-4C, the RICO conspiracy statute. Georgia law is clear that where a defendant is charged under a specific conspiracy statute that contains its own penalty, 1648 has no application whatsoever, because it is the intent of the General Assembly that the defendant be punished under the specific statute. Where that specific conspiracy statute calls for the same, makes the same punishment available for a substantive and a conspiracy violation, the court has the full range. I think this is just hypothetical, because it would have no application unless Your Honor is sentenced to more than 10 years for the conspiracy, which would be more than 50% of the 20 years available. We haven't asked for that. I've seen no indication that the court intends to do that, so I think this is a bit of a waste of time. But the cases on that are Roe versus State, 181 Georgia Appeals 492, McWhorter versus State, 275 Georgia Appeal 624. There is no confusion as to which statute applies.
So under Roe, this is a misrepresentation. Under Roe, the court reversed the trial court for imposing a punishment under the wrong statute. So that's Roe. That's why I'm asking the court to take a look at this. It also makes a difference in terms of when the defendants will be eligible for parole, that they are convicted for RICO as opposed to conspiracy. I would also note, Your Honor, for the record, that if the state's contention is that the crime of RICO was actually committed, then it would be my position that the crime of conspiring to commit a crime, that would have to be set aside. Where the evidence shows that the crime was complete, a verdict of guilty of conspiring to commit the crime is not authorized and must be set aside. That's black letter law. So I would only ask the court to take a few minutes to take a look.
I'm ready to
All right, very well.
go. And Mr. Davis, I've listened to you for 3 years. Go ahead, Ms. Johnson.
Your Honor, may I approach?
Yes, ma'am.
Man, should I approach with you or this matter?
I don't know what's going on.
That's okay, we'll clear it up.
We'll leave her to last then. All right, Ms. Davis Williams, you want to come up?
Good morning, Your Honor. Your Honor, on behalf of Sharon Davis Williams, and just for the record, I would like to join in the motion that has been argued here this morning by Attorney Benjamin Davis. I would like to add to that, Your Honor, that one of the things, while it is important to determine under what statute these defendants are being sentenced, is because
They're being sentenced under RICO. RICO. That's what they were indicted for. That's their, and conspiracy to commit RICO is the same as RICO. So that's, I've looked at it and I'm comfortable.
if I could just perfect my
Okay.
argument for the record, thank you. That would also, if they were in fact, Your Honor, sentenced under the statute of 16-4-8, then that would also give us the ability to make an argument that the law allows the court to consider giving them misdemeanor punishment. And I know the court is not inclined to do that. But if in fact they were sentenced under 16-4-8, that is one of the requests that I would have made on behalf of my client, Sharon Davis Williams, who the court is aware has no prior record. That being said, Your Honor, and understanding the recommendation of the state, I'd just like the court, as I stated on yesterday, that I had my witnesses to come up to make a statement, and I just want to, on behalf of Sharon Davis Williams and myself, make the court aware of a couple of additional things. As Your Honor knows, my client entered a not guilty plea 2 years ago. She's maintained that guilty plea. At the time, Your Honor, as the court is also aware, they were given plea. We entered into plea negotiations. There was a plea offer made to my client, a very, in most of people's opinion, probably would view it as a very good plea deal. And my client, Your Honor, despite that, a better plea deal than the sentencing recommendation is being made today. And despite that, my client turned that down, entered her not guilty plea, and has maintained her innocence throughout this trial. I would ask the court, understanding that the jury has spoken, the jury has found my client guilty, Your Honor, of 1 out of 4 of the charges, or out of the 3 charges. I would ask the court that to consider that there was certain evidence presented in this case. I know you listened attentively, and I'd ask the court, in rendering a sentence and punishment against my client, to remember the evidence that was presented against Sharon Davis Williams. Even those principals, Your Honor, who came in and said that they felt pressure, all acknowledged that my client, Your Honor, at all times was a good SRT or a good executive director, that she treated them humanely, Your Honor, that in instances where she could have gotten rid of them, in instances where they did offer their resignations, that she went above and beyond to help them. A principal had a sick parent, there was a principal who had to go out on medical leave, and at all times she did what she could to support her principals. And I would just ask the court to give that some consideration. If it was the objective of my client to get rid of she was given multiple opportunities, and you heard the evidence. Your Honor, on next month, May 3rd, my client will turn 60 years old. As I've said before, she has no criminal record whatsoever. Prior to this incident, she'd never even been arrested. She was born in Marianna, Arkansas, and she was raised by her maternal grandparents. The court knows that she has spent over half of her life in the education system. I would ask the court to take all of these matters into consideration. I understand, and I would not want to be in the position that Your Honor is in. I understand this case has been well publicized. It's a very political case. There's very sensitive issues. What I'm asking this court to do is, despite the recommendation, is if the court would consider giving my client 5 years probation, Your Honor, allowing her to participate and give back, to try to redeem by participating in this program that Ms. Willis has just outlined. She's a bright woman, she's an intelligent woman, and that program could certainly benefit from someone with her expertise. I'd ask that in addition to giving her 5 years probation, Your Honor, that the court allow her to be sentenced under first offender, and that the court also grant her an appeal bond. In essence, Your Honor, allow her to maintain the bond that she was on prior to being taken into custody. I know that on yesterday morning we spoke briefly with the court along with the state, and there seemed to be a willingness to do that.
The things have changed. Things have changed. So, you know, we'll have an appeal bond hearing in 30 days. At that time, I'm going to need to know whether there is counsel in place for the appeal. If not, whether there's a petition for indigency so we can appoint somebody to represent her in appeal. And at that time, we'll address the appellate bond.
Again, Your Honor, if I could just finish my statement.
I'm just letting you know.
I appreciate that, Your Honor.
I don't care what we discussed yesterday.
Well, then there's an issue because I advised my client on what we discussed.
Okay, well then,
And Your Honor, you
there's no deal here about anything.
There wasn't a deal, but there was a discussion as to the.
Okay, well, that was yesterday and this is today. So let's just move on.
Advice to my client.
Well, maybe you ought to advise her because I've just told you what's going to happen.
Well, Your Honor, I'm in a similar position. You stated in open court that you would grant these defendants an appeal bond. You stated that on the bench, and
that was before I said, please.
It was while you were saying that. You said,
Please.
I want to give them an appeal bond.
Okay, well, anyway.
Your Honor, I'm going to join that objection in regard to my.
Okay, make it a blanket objection. Everybody objects.
I need to put on the record why it is that we made a recommendation to our client based upon a pronouncement that was made by this court in open court on yesterday.
Okay, well, I'll give you a 15-minute break and you can tell them things have changed.
But Judge, and also, important for us to know, for the court to be aware of the fact that when we were in your chambers yesterday, when Mr. Howard discussed this deal, that you put Mr. Howard out and you said, because you're the sentencing authority, Judge, there is no plea. My client's been convicted by a jury. You put Mr. Howard out, and then you told us that you were going to sentence our client to prison, but you would grant first offender, and that you would give us an appeal bond. Then you confirmed that in court on the record, Your Honor. And now that you're upset that we didn't listen to Mr. Howard's plea deal, I think that is inappropriate.
Okay, fine.
And Judge,
that's fine. There's probably a lot of people think a lot of things I do is inappropriate.
Your Honor,
but
I am making a motion for you to recuse yourself from sentencing my client, since you are not making your decisions based. Apparently, you're going back and forth based upon motion. And Your
Honor, the state would ask that you give these defendants until 11 o'clock with their clients. But we do.
Yesterday, we were ready to be sentenced.
you sit down, I'm gonna put you in jail. If you yell at me, point at me.
You yelling at me, Judge. I'll be quiet. I'll whisper.
Well, I will say it on Ms. Butler Webb's behalf, Your Honor, and I'm speaking loudly so that the court can hear me. All right? Yesterday, we were ready to be sentenced. We came in here ready to be sentenced. At your direction, you asked us to have a conversation with the district attorney. It was not a conversation at all, Your Honor. And so we are in the same position as we were on yesterday when we came in. Representations and discussions have been had with our clients based on what you said in chambers and what you said on the record. Your Honor, it is not appropriate for you at this point to have them sit in jail another 30 days simply because the court is upset that we didn't apparently arrive at some sort of deal with Mr.
Okay,
Howard.
well, I'll
It
let
is
you,
not appropriate. And we're asking that you
I'll grant an appeal bond. Just, you can have an appeal bond. Let's just go ahead with this.
They did want to be heard on that issue.
Okay. Anything further?
Yeah, we're still up here. This is still Sharon Davis Williams. And again, Your Honor, I would ask the court to consider probation. I've got to put this on the record, consider probation, allow my client to have first offender, and that she be continued for appeal purposes on the bond that she is already on.
All right. I sentence Ms. Sharon Davis Williams to 20 years to serve 7 with a balance on probation, 2,000 hours of community service, $25,000 fine.
I'm sorry, Your Honor, for my
And
purposes.
that's the only charge. 20 years to serve 7.
The balance on probation.
Yes.
And the,
2,000 hours of community service and $25,000 fine.
and her bond will continue, correct?
Yes.
Thank you. Are you granting first offender, Your Honor?
The state would object.
No.
Welcome to order. Your Honor, the court has stated that part of the reason the court was considering jail time now was because the defendants didn't accept an offer or take responsibility early.
I'm giving my sentence based on your client and those similarly situated. Ms. Sharon Davis Williams and Mr. Pitts were at the very top of this scandal, at the very top. And everybody in the education system and APS knew that cheating was going on, and your client promoted it. That's where we are. She's been convicted, and she's at the top of the food chain.
Your Honor, not one witness testified that my client directed them to cheat.
Your client ran numerous fine educators out, non-renewed them, fired them. She was responsible.
Could you name the educator you're talking about?
The one in Texas that, got superintendent of the year after he was run out of Atlanta.
Well, he was.
Well, anyway, go ahead.
Very well, Your Honor. What I wanted to say to the court is, as you are aware, Ms. Cotman was found not guilty in the first trial. Her case.
The jury, I understood, said if it cheating was the issue,
They
they would have
said-
come back in
They-
5 minutes.
If I could I have the microphone right now. They never said that.
Yeah, they did. They said it in the jury room.
Your Honor, you weren't back there, so you wouldn't know what they said in the jury room. But the point I was trying to make to you is Ms. Cotman's appeal. She was found not guilty. Ms. Cotman's appeal wasn't decided until August the 13th of 2014, after this trial had already began. So there was no prior occasion. I understand this is part of your decision making. There was no prior occasion for her to take the deal or to get off the bus as you are talking about it, because her appeal wasn't decided until after the case had already started. So part of that rationale was not applied to Ms. Cotman because she was found not guilty. And I might not add that all of the educators of the court is speaking about were part of the first trial. I understand that the court is standing by the jury's decision. I'm assuming that the court will stand by the jury's decision in the first trial. So I wanted to point out when her appeal was adjudicated, because it wasn't adjudicated until after this trial had already started. So there cannot be a claim that Ms. Cotman could have accepted responsibility before this trial, or she could have accepted the plea deal, because she was found not guilty of what the state alleged that she did. And her appeal wasn't decided until after the case had began. I would also just point out to the court, on the Uniform Superior Court Rules 33.6, that a defendant can't be punished more severely because that defendant requires the prosecution to prove his or her guilt at trial rather than to enter a plea of guilty. So, Your Honor, that's what I want to say on Ms. Cotman's behalf. I think that you know a lot about her.
Yeah, I know a lot about her. I know more than I ever wanted to know.
Well, could you expound upon what you think?
No.
Well, what I'm saying is there is no one in this courtroom that can state one fact about Tamara Cotman that would indicate that she did anything wrong. I would also point out, in the state you'll get an opportunity, but I would also point out that according to the AJC, Ms. Cotman, in terms of the people who were convicted, it took them the longest to reach a decision with regard to her. There were no predicate acts with regard to Ms. Cotman. There was only one overt act that related to an individual by the name of Aquarius. His last name escapes me right now. Clark. But the court will recall that that exchange with Teresa Reese, that matter was fully investigated. So when we're looking at the evidence and when the court is specifically reciting witnesses that stood out to you with regard to Ms. Cotman, there is no one that saw any cheating. There is no one that said she directed the cheating. Even Mr. Milstead testified that there was no cheating at his school and that he didn't see any cheating. You'll recall that he was a witness.
Mr. Milstead said, Ms. Cotman, you know, these scores are incredible coming from grammar school. These people can't read. These kids can't read. And when they get to middle school, I look at these scores and they are totally bogus. And so Ms. Cotman fires him.
No, Your Honor. What happened was he stated at a meeting where there were other elementary school principals there. Well, just let me respond. He stated at a meeting where there were other elementary schools there that he thought there was an issue. And what he testified to was that Ms. Cotman said, you know, it's really not appropriate for you to be saying that in front of the very principals that you're trying to accuse of something. But his testimony, if you look at it, was that not only during this trial, but at the prior trial and at the 404B hearing, is that he saw no cheating. And there was no cheating at his school. He was speculating as to what may have happened at a school before the kids got to him. But he never saw any cheating, and he testified there was no cheating at his school. There's not one witness. There's not one witness.
Okay, well, you know, she's been convicted, and I'm not trying the case,
Right,
and
well,
I'm not prosecuting the case. I'm just sitting here trying to give a sentence. So do you have something nice to say about your client?
I've said a lot of nice things. You know, I think that you may already have a sentence in mind. I wanted to point out what I understood to be sort of what you were really concentrating on when you were giving out the jail sentences. And what you stated yesterday was that it was retribution, mainly because the defendants hadn't taken the plea when you had expressly told them you should take this plea, or you had intimated that to them. And what I was trying to point out to you about Ms. Cotman is she was found not guilty, and her appeal wasn't decided until after this trial had began. So there was no opportunity before this trial to get off the bus, as you have stated before. And
What are you talking about? Get off the bus?
Get off, you know,
I mean,
talking about a train yesterday, I'm sorry.
She could have pled guilty at any time.
She couldn't have pled guilty before the Court of Appeals had made their decision. I mean, you don't disagree with that, right?
I'm talking about before the trial started. During the trial, I invited everybody to review the evidence that they had witnessed so far and maybe reconsider.
But Judge, she was acquitted of what she was accused of doing.
Okay, all right. Well, I mean, I understood you the first time you said it. I understood what you were saying.
Very well.
Okay.
That's all I have, Your Honor. I would ask, of course, that you give her first offender treatment. I'm also asking that the court consider appointing me to do the appeal. Not for me to get paid, but if you would just pay for the transcript. You already declared Ms. Cotman indigent for the purposes of the transcript. If the court would just sign an order.
When did I do that?
You agreed to do that in the trial so we can get Ms. Cotman's transcript from the prior trial. You signed an order finding them indigent for the purposes of paying for the transcript. The state consented in that order.
All right, well, that's sounds fine to me.
All right, very well, y'all have an order then for the court to consider, take a look at it.
So Evelyn, I guess you can start.
And you'll also have the order for the appeal bond. I want to hand up to the court.
Your
Right,
state
Evelyn?
would like to see the appeal bond prior to it being signed.
Okay. All right. Ms. Cotman, you've got one count. I sentenced you to 20 to serve 7 with a balance on probation, 2,000 hours of community service, and a $25,000 fine. You got 30 days to appeal, to file a notice of appeal. Looks like Mr. Davis is going to handle your business pro bono, and we're going to ask the taxpayers to pay for the transcript because it's 20,000 pages. Is that right, Evelyn?
That's correct.
All right.
Now, Judge, I want to ask one other thing. If the court, if you take a look at my argument and later on you agree, will you reduce the sentence, the length of the sentence back down to 10 years? If you take a look at it, I'm requesting that you do that, consider it, take it under advisement, and I want to just leave it open where the court can hear my argument today, take a look at it, and consider sentencing them under the conspiracy statute. Because if we're talking about cost involved, if the Court of Appeals, I'm saying if they find that you sentenced them under the wrong statute, the case will get reversed if for no other reason for you to re-sentence them under the conspiracy statute.
Well, that's not a big deal.
Well, I understand that, Your Honor, but I'm just bringing up that point because the state was talking about the cost. And I just want to show them this form. It's going to be the same form for everybody. The state one. You also have the one for the appeal bond.
Is it still be an appeal bond hearing? Is that what it is? I thought it was an appeal bond.
He's already returned.
I sit them down there for 10 or 12 days, and they can, I guess, sit outside and then think about going back once this is over to whatever their sentence is. And, I just wanted them to get a taste of it. And apparently that didn't quite move them.
And I've already submitted an order, Your Honor, when I filed my appeal bond motion, so the court will sign that as well. Thank you.
And
All right.
I also just wanted to make sure my argument was clear from the record that on behalf of Ms. Cotman, I was also moving to set aside the verdict because if the state's contention is that we're not talking about a conviction under the conspiracy statute, we're talking about a conviction of the substantive count of RICO, and that's how the verdict form should have read. The verdict form reads conspiracy to commit RICO. The verdict form does not read RICO. So if their contention is that the conviction and the sentence is under the RICO statute, then that's the way they should have fashioned the verdict form. And under Georgia law, there's a clear distinction between a conspiracy to commit a crime and committing the crime itself. Under Georgia law, if the crime is committed, then any conspiracy conviction would have to be set aside. All right. Very well, that's all I can say.
Sounds like you're in great shape for your appeal.
Your Honor, simply for the record, the state utterly, completely disagrees with that argument. I'm not going to burn more time now dealing with it. If we need to submit a brief, we'll be happy to do so.
Well, Judge, and I wanted to point this out in response. They cited Roe.
Okay, I've heard enough.
Well, let me just hand you this one case that he cited. He cited Roe versus the state, and this is a copy of it.
I'm burned out on this issue, and it's in the record, and
If you look at the last page, you're going to see that the Court of Appeals reversed in the case that he cited, which is Roe versus the state.
okay.
Your Honor, I'm not speaking on that issue. The state would also ask for Tamara Cotman and first offender be denied. And that was not stated.
I didn't sentence him first.
Okay, I just wanted to make sure the record was clear.
Morning, Judge.
Morning.
I think you probably know very little, if anything, about Michael Pitts. Michael Pitts is a 30-year educator who spent his entire career working with inner city kids, as his daughter indicated. It is odd that no one from either side told you what the disagreement was as it related to talking about deals for a recommended sentence. It wasn't that Mr. Pitts does not have some remorse about what happened in the Atlanta public schools. That's not the case. The issue, Judge, is that
What is his remorse that he got convicted?
no, Judge, I don't think it's his remorse that he got convicted. That was always a possibility when any defendant decides to go to trial. The remorse is that all of the situations that transpired comes down to Mr. Pitts, not as to what he did, as to what he knew and when he knew it. That was the situation with Mr. Pitts. I don't think anyone came in before you, and unlike some folks, I sat here through the trial with you every day except those few days that I may have been absent. And you may be of the opinion, and somebody else may be of the opinion, that Mr. Pitts didn't have adequate representation. That may be the...
No, George, you're one of my best friends in the law, and I admire the way you defended Mr. Pitts. You were excellent, and I'm just sorry it's come to this. I'm very
I
sorry.
am too, but all I want to tell you, and I hope you will be patient and listening at what I want to try to tell you on behalf of Michael Pitts. Mr. Pitts was the first SRT person that Dr. Hall hired when she came to Atlanta in 1999. She hired him in 2000. Mr. Pitts is therefore the senior person. Mr. Pitts came from the inner city schools that were bad in Memphis, Tennessee. He was assigned to the schools that were not doing very well, and that was his choice. That's his choice. Now, obviously, he would have been in a position based upon his seniority to say, give me the best of the best schools. Those persons who probably had the best of the best schools are not sitting here today. That's neither here nor there. That's a decision from the district attorney. All I'm suggesting to you is that what was portrayed to you as to who Michael Pitts is totally different. Mr. Pitts is a very quiet man. He's a very reserved man. He has been like that since I met him, and he's been like that today. It would have been very easy for him to come up here and tell you, Judge, I'm a convicted racketeer. That doesn't change the fact that he has been convicted. The presumption of innocence is not with him anymore. It's not there. But all I'm suggesting to you, Judge, that 20 years to serve 7 years for a man who has a stellar career for 30 years is probably, not probably, but is an unfair and unjust sentence. That's your decision. The jury doesn't sentence, the court does. All I'm suggesting to you is that, and you probably made your mind up. You probably have. But there is a better way to do this for Michael Pitts than 20 years to serve 7.
So he takes no responsibility, Mr. Lawson. He was at the epicenter of the cheating. Parks Middle School was the #1 cheating school in the state of Georgia, and he was the director. And
Judge.
Waller,
Judge.
you know, he comes in here, I mean, you know, I don't know, I don't know why he's saying he can't understand what's happened to him, or that he's not taking responsibility because he was in charge of that school.
Judge, I think you're missing the point what I just said.
Well, tell me what the point is.
My point is that Mr. Pitts, a person of character, does take responsibility for what happened under his watch. The only thing Mr. Pitts can't tell you truthfully, and I can't tell you whether those witnesses were lying or not. Mr. Pitts can't tell you, stand here and tell you, Judge, although he's convicted, he can't stand here and honestly and look you in your face and say, Judge, I am a convicted racketeer and I accept that verdict. Mr. Pitts accepts responsibility for what when we go back to that civil standard, what he should have known. Well, I brought you the person who was there supervising parks from the state of Georgia, who saw none of this. But when we put a responsibility on Mr. Pitts, who had 15 other schools, 5,000 students, 700 teachers under his supervision. Judge, I wish you had had the opportunity to have supervised Christopher Waller. And what your analysis is, Judge, if there is a judge in this courthouse, and I don't suggest that there is, who is a corrupt, immoral, and a bad judge, because you sit on the bench with that person, you knew or should have known that that person was wrong. And that's what Mr. Pitts is being charged with, primarily, what he knew and what he didn't know and what he didn't do. No one has ever told you that Mr. Pitts did that. And that account that he was convicted of, I asked you for a directed verdict on. Here's a young lady who said, this is how I felt about reporting something to the GBI and the governor's investigators. Judge, they hadn't even been appointed yet. How can he, and she hadn't told him he was a cheater. If she had told him that she was a cheater, I wouldn't stand here and tell you that. I think you know I would not. I don't know how you stop somebody from doing something before the entity even exists.
Well, it's like Reverend Young said, you know, the people should have rose up and said no, but they didn't. And, you know, here we are. Here we are.
Here we are. Judge, in your heart of hearts, if you believe that Michael Pitts intentionally did something to harm a child, that's another thing. I would respectfully disagree with you.
I think there were hundreds, thousands of children that were harmed in this thing. And that's what gets lost. Everybody starts crying about these educators.
Judge, you haven't heard
and that's
one time about that.
What? There were thousands of children that were harmed in this thing. This is not a victimless crime that occurred in this city. And I have sentenced them. This was going on right after, when Beverly Hall got here, Mr. Pitts got here about the same time. From 2001, there was whole-scale cheating going on in the Atlanta public schools, and these kids were passed on and had no chance to begin with because of where they lived, who their parents were, who their, you know, just their situation. And the only chance that they had was the school
Judge,
to get an education. And when you can't read, you're passed on and passed on. There are victims that are in the jail that I have sentenced, kids. I don't like sentencing. I don't like sending people to jail, but, you know, sometimes that's what's necessary.
We always say those things that are bad, but we never talk about the good things. When Dr. Hall, and I'm not here to defend anybody except Michael Pitts. What about those kids who were 5th, 6th, 7th, and 8th, 9th, 10th graders, 11th graders when Dr. Hall got here? If it's this court's opinion, and if it's this court's opinion, there was no impropriety in the education system, and APS when Dr. Hall got here, I beg to differ with you. If you are of the opinion that this school system called APS is not better now than it was then, I choose to differ with you, Judge.
So everything's great.
No,
This whole
sir,
thing was
it's
just
not.
a wonderful,
It
thank
was
God,
not. It is
Dr.
not.
Hall
It
came.
is not. It is not.
We're so much better off.
Or maybe you don't believe what, it is what it is, Judge.
Okay.
It is what it is.
It
My
is what it
only
is.
request is that your original thought process as it related to Michael Pitts of 3 years to serve is an appropriate sentence. That is an appropriate sentence under the facts in this case as it relates to my client. I still ask you, does it make us any better for Mr. Pitts to walk out of this courtroom today without first offender? I would suggest to you, no. It doesn't, Judge. It doesn't. It just really doesn't. Now, that's, Mr. Pitts may have something that he want to say to you, Judge, and I don't know whether you want to listen to that.
I know, that's fine.
Good morning, Judge. I think we've looked at each other across the aisle many times, and I want to be reflective, and I want to explain that there's two sides to a coin. I'm very distraught about seeing people who did something wrong to children. I saw it simultaneously, and maybe I should have known. But on the second side of the coin, when I was in Memphis, equally, and I'll tell you a quick story about when I came to Atlanta. I went to my elementary school. 4th grade was the grade that we actually checked. 9% of my kids were reading, 91% were failing. I went into the school, the teachers weren't teaching. It's the same kids who were going to jail. It wasn't for erasures or cheating, it was for lack of teaching, lack of caring, just lacking. I turned the school around, I turned many schools around here in the city. I've probably been in every inner city in Atlanta, every inner city school in Memphis. Dr. Hall asked me to come to Atlanta. I came to Atlanta. My daughter urged me to come to Atlanta. And I went to the first graduation in Atlanta for Carver High School, which was in my SRT. And I've never seen anything like it. It was actually 23 chairs on the stage. This is the first year, second year Dr. Hall was there. 23 chairs were on the stage. And I said to Dr. Hall, did you send me to this area where the kids go into the high school and 23 kids, you couldn't even make the C for Carver like they make it in G for grade. And I determined right then that we put high level work into the schools, work hard, work schools just like the Buckhead School, and we did. We worked very hard. I'm not making excuses. People like Mr. Waller came in 5, 6 years later after I got there. I think they looked at the hard work that we had done, and I don't know if they thought they could keep up. I would have never thought, I didn't know this man very well. A lot of transition happened when we worked very hard to get schools to read.
Y'all hung out together. You and Mr. Waller
I
did.
have no idea of hanging out with Mr. Waller.
Oh, okay.
At all. No, I do not.
I get what he said, maybe you
Mr.
did.
Waller
I
came
don't
in
know.
about 6 months. I think when he walked in the door, I didn't hire him. Of course, he came in. He worked hard. But I didn't have any idea that he was trying to keep his status or he wanted to keep up. I didn't know.
Well, when he shows up, and then all of a sudden, there is this
Well, it was
this total turnaround that is just
was
totally preposterous. I mean, what'd you think about
I
that?
turned my school around, sir. I actually, when you put certain things in, Mr. Waller, one thing they did do, they implemented a lot of good discipline. Students began to take tests. One of the things about the middle schools when I came in, the kids were just Christmas treeing the tests. They wouldn't even try. Mr. Waller and other principals came in and they made sure that the kids did sit down, did attempt to take the test, did go over it. It was one incident that I did report where his scores in science went up, and I did turn that in. But other than that, it was just like the state monitor said, it was a gradual movement.
Well, did you see all those letters that were sent
What did I say?
to you and Beverly Hall and everybody about what was going on
The
at
last
Courtroom?
thing I want to explain, when I came from Memphis, we investigated everything as a principal. That was what my job was. I turned in cheaters, I turned in people who abused children. When I got to Atlanta, they have a system called OIR. Under the OIR system, basically, when anonymous letters came in, it went to OIR. The reason why they wanted separation, we sent things in as executive directors. They took it over. We were not to do anything until we got a disposition letter at the end. And the way, I never got a disposition letter on parks. Disposition letters mean that all I do is whatever recommendation of OIR and the superintendent, because I go tell the principal, this is what came up. If they wanted the principal removed, this is how they got removed.
So you're just pretty much telling me you had no idea that there was just blatant cheating at that school?
No,
Is that what you're telling me?
No, sir. When I realized cheating went on in that school is when Mr. Waller got on the stand, Mr. Salters got on the stand. I thought Mr. Salters was one of the greatest principals I've known. He sits here, I don't know his fifth grade teachers in pockets of cheating. I just didn't know. If I'd known, I'd have turned it in. I'm not trying to make excuses. I should have known. I mean, I look at just me talking. I watch the jury, and I'm just being sincere. And if they're able to go through tests and look at shadows and all of those things, we did not have the opportunity to do that. We didn't have the opportunity. Racial analysis, I think, ultimately, and this is just for the good of the world, could be a good thing. The thing is, if you give it to me in 09, I've never seen one before. We didn't have enough time to react to that. However, I think if it was done to the point where we could go out, help schools, and now identify people who are doing these things wrong with that kind of technology, we would have helped systems across the country. It shouldn't be done to get people. It should be, I mean, if we had done it and we did it 2 or 3 years and we ignored it, I think this would be appropriate setting for neglect, and it would be appropriate setting for people doing some sort of recollect. We did not have time to react to any of that. We never see the test sheets. We never see the test scores. The erasure analysis came in 09. By that time, we were in the middle of all of this, and we couldn't react. And I mean, that's just the truth of it. I left Tennessee. I was a distinguished teacher. I was a distinguished principal. I had an inner city school. We did value added. We were top 5 in every area in the state. We were top 5 in reading. We were top 5 in math. We were top 5 in science. And basically, it came from hard work. It came from the kind of work that we implemented in the SRTs in Atlanta. This is what I tried to do. Ms. Evans was one of my principals. She can tell you I never oppressed principals. I have not fired one principal in Atlanta. Not one in 15, in the entire time I was there. The only principal that left my SRT was because of improprieties such as sexual or abusing teachers, and that's the truth. I believed in the velvet hammer. In other words, I believe that you have to teach children just like I taught my own child, but I do not believe that because kids are in the inner city, that people should not be accountable for doing the work they should do. But that does not mean you oppress teachers and principals. I think had you known my principals or you see any one of them will tell you that I have never, ever abused them, even screamed at them. In fact, I make sure they don't do that. That's who I am.
Judge,
Thank you.
5 years to serve, 3 years to approve the sentence, Judge.
All right. My sentence for the count 1 is 20 years to serve 7, balanced probated, 2,000 hours of community service, $25,000 fine, and you can have an appeal bond, 5 years to serve to run concurrent on the influencing a witness.
Judge, I'll submit you this afternoon in that order for the appeal bond.
All right.
Morning, Judge. Judge, during the course of the trial and yesterday, we heard a great deal about Dana Evans, so I don't need to rehash that. And we heard your words about Dr. Evans as well, and we appreciate your being willing to say that publicly. And I know how difficult this particular case is for you. There are two things that I'd like to address in response to kind of the discussion we had late yesterday. The state has said acceptance of responsibility is important, and it's an important aspect of sentencing. I understand that, and that's pretty much axiomatic. Mike Bowers and Bob Wilson, in their special investigators report, made a special note and pointed out that Dana Evans was the only principal to take responsibility for what happened at her school. Now, and you heard her yesterday, she's not saying she engaged in cheating or engaged in a racketeering conspiracy, but she is taking responsibility because she was the leader, or as Bob Wilson likes to say, the captain of the ship. And he was impressed by her. The court heard the interview with Dr. Evans and the special investigators. So I would point that out. You heard her acknowledgement of what happened at her school under her leadership yesterday. The second point I'd like to address is that of the children. And we should all be concerned with the harm that as a result of cheating, the way kids were moved forward without having the skills to back up that advancement. I would ask the court to recall the testimony of each and every one of the educators who swore under oath and testified in this trial, 14 of them from Dobbs Elementary, about the things they were doing for the children. Regardless of what CRCT scores they had the year before, each kid started with a blank slate with an assessment, and the remedial tools that were in place were put in place based on how they were doing that year. They weren't put in place based on the previous year's CRCT. So if a child in 2009 did well on the CRCT, but in 2010 couldn't read or do math, they were given the remedial tools pre-school from 7:35 to 8 o'clock every day, during school, after school, Saturday school. And the court heard all this. Educator after educator came in and talked about that, and the court knows that even the things that Errol Davis tried to put in place to remediate the harm done to these children was already put in place by Dr. Evans. She got $1 million grant spread over 3 years to do the exact same things that Errol Davis thought needed to be done well after the fact. That was already being done at Dobbs Elementary. I think it's clear that Dr. Evans' primary concern for the years at Inman and for her short tenure at Dobbs was to help the children, to help them move forward, to make college a possibility for kids who weren't even graduating high school. That's what she did. That's the culture she tried to impose on Dobbs, a school where cheating was already occurring before she ever got there. And of course, the principal who was in charge prior to Dr. Evans never had to face what Dr. Evans has had to face. And so the children was a primary concern. I just want the court to recognize that. The other thing I'd ask the court to remember is that the Professional Standards Commission cleared Dr. Evans of the charges that Sidney Fells leveled. And Sidney Fells did not say that Dr. Evans knew there was cheating. Sidney Fells said Dr. Evans created an atmosphere where cheating could occur. The Professional Standards Commission and David Pumphrey investigated those allegations. Fells said Dr. Evans created an atmosphere where cheating could occur. The Professional Standards Commission and David Pumphrey investigated those allegations and cleared Dr. Evans. We talked in chambers yesterday. And I know the court has said today is a new day. I don't know what happened between yesterday and today to make the court want to give Dr. Evans a longer prison sentence than the court said.
How do you know that?
I don't know what happened.
I mean, how do you know what the sentence is?
I don't know. Maybe I'm making an assumption that I shouldn't be making.
Yeah,
Boy, am I
maybe you
stupid
are.
for doing that.
Yeah, maybe you are.
Well, I apologize
Okay.
then. I'm asking the court to grant Dr. Evans first offender treatment, to sentence her to a period of 5 years probation, intensive probation if the court deems that necessary, house arrest if the court deems that necessary, whatever conditions the court wants to impose, we think would be appropriate, but we don't think Dr. Evans should go to prison.
Well, anyway, this is a really hard case, and I believe that Dr. Evans was told about what was going on in the 4th grade. I believe that, and there are multiple sources that testified about it. But my sentence is 5 years to serve one, balance, probated, 1,000 hours of community service, and I'll let her plead under the First Offenders Act. Not plead, but just sentence her.
Treated under the first offender.
Treated under the first.
We appreciate that. Judge, we've provided Ms. Dobbs with the order for an appeal bond. I did not show it to you.
Okay, if y'all can just gather those up, I'll sign them before I leave the bench. Okay.
Thank you, Your Honor.
Evelyn, you need a break, or you?
I'm okay.
You're okay? All right.
Yeah, I'm okay.
Good morning, Judge.
Hello.
As you know, this is my client, Angela Williams. She's 48 years old, and her family is here, and they've been here for a majority of the case. You just stand up. She is the second youngest of 13 children from Ailey, Georgia. You got to hear from Gary Brady, who came up from Ailey, from Montgomery County, to tell you about Miss Williamson and her family. She's been married to Jimmy James Williams for 19 years, and she has 2 wonderful children, Danielle, who's 15, and Noah, who's 10. And she's been an educator at Dobbs for 14 years, where she was a paraprofessional as well as a teacher. I know your primary concern in this case is the children and responsibility. Ms. Williamson, from all accounts, from every child that came in to testify, both for the state and for the defense, was an excellent teacher. From every teacher that came in from Dobbs said she was an excellent teacher. Her children that were brought in were not reading below grade level. In fact, they've gone on to be the valedictorian at South Atlanta, the number 5 at South Atlanta, and an AB student at Carver. You heard all these things, Judge. And Ms. Williamson takes responsibility for the academic success of her children, both her own and the children that she has educated for the last 14 years. Ms. Williamson has no prior criminal history whatsoever. She was a graduate of Fort Valley State University. She also has her T6. She has been dedicated to both her family and educating children. Ms. Williamson, when we reflected a few times that we were at the jail, she just wanted to know how everyone else was doing. That shows you the type of person she is. For the first time in the 4 years I've represented Ms. Williamson, yesterday, I saw her break down. Not for herself, but for the stories that were being told about these educators. And Judge, I'm asking you, as humbly as I know how, for mercy and justice tempered with that mercy. The same thing that Ambassador Young asked you for yesterday, the same thing that Judge Moore asked you for yesterday, the same thing the 35,000 individuals who signed the petition asked you for over the last week. I understand that there are members of this community that want to see this young lady go to prison. But that would serve nobody in this community. She has talents that she can use to help the DA's office get their redemption program up and running, or that she can go to the jail and the GED program. The only issue with the deal that was given by the DA's office that I found out about yesterday was jail time. She wants to raise her children. She wants to be there as she's been, as Jimmy told you, for all their life.
Well, why didn't she think about that 18 months ago? I don't know what trial you listened to, and I have, the evidence shows she was a great teacher. She was a good teacher. But the evidence for her case was the most overwhelming in the whole trial, that she cheated. And her best friend said she cheated. They got together and cheated. And these children came in and said that they saw her cheating, yet, here we are, and she didn't need to be taken away from her kids. She didn't need all this. She could have just accepted responsibility, and that would be the end of it. So, I don't know, for you to, the evidence was overwhelming of her guilt of cheating.
And Judge, respectfully, I'm the only person that has sat through not one, not two, but 3 trials. So I've heard the evidence 3 times. I've heard it 3 different ways. I heard it 3 different ways from that witness stand. I heard it 3 different ways with a chicken biscuit from that witness stand. And I also understand...
You and the chicken biscuit and the multicolored coat and all that stuff, you didn't do anybody any favors with all that stuff.
Your Honor,
okay.
I am here for Ms. Williamson to be a protector of that flag that sits behind you, and that's the constitutional right to a fair trial. She had a right to that. That's all we wanted.
She had a fair trial.
Your Honor, we're asking you in this point, because the purpose of a sentence, and you said it yesterday, was to rehabilitate and to punish. And you said sending someone to prison, the only service that would do would be retribution. We've heard from the children that said they don't want their teacher going to prison. We've heard from some of the parents. Vanessa Haynes told the AJC she doesn't want Ms. Williamson going to prison. She said that. So, Your Honor, I'm asking you to follow the recommendation of the children and their parents and sentence Ms. Williamson as a first offender so she can take care of her children, so that she can pay back her debt to society, so she can accept responsibility and help the children learn. And again, with regard to the children that were in Ms. Williamson's class, they are still avid learners. So I'm asking you to sentence her as a first offender to probation, to grant her an appellate bond so she can return back home to her children while this appeal is pending. And I'm asking you to temper justice with mercy. Thank you.
All right, I'm going to follow the state's recommendation. 5 years to serve 2. What was the recommendation on community service?
Your Honor, the state, actually on Ms. Williamson, we also object to the first offender. As far as any community service, we would ask that she be given community service in the amount of 1,500 hours.
1,500 hours
And then
community
the fine was
service.
$5,000 what the state requested.
$5,000 fine. And no first offender.
Your Honor, I just had one question. How is she going to be able to pay $5,000 if she...
I don't know.
And are you granting her the appeal bond?
Yes.
Thank you, Your Honor.
Good morning, Judge.
Hello.
Need a break?
No.
jury's found guilty, we accept that verdict as we indicated on yesterday. And even if after there are not guilty verdicts on the 2 predicate acts, one would still want to look at those 2 things that she was charged with, or the 2 tests. We're talking about 11 tests that were flagged in 2008. And we're talking about the test of 2009 being so insignificant that the expert witness says that he couldn't find any evidence of human intervention, if you recall his testimony, in terms of his statistical analysis. The gentleman from okay.
Deerwood is where this whole thing started. The whole thing started at Deerwood.
I understand that was the initial point where the investigation began. I do understand. You know, we come to this court looking for wisdom and sober-minded decisions. And when we had a discussion with this court yesterday, I was pleased that I felt that the court had contemplated long and hard about what its decision was going to be in these cases, and reached what seemed to be a reasonable conclusion. I told you on yesterday about Ms. Jordan. I've told you, and so has her parents and her friend. I've told you about how she clothed young students, how she provided transportation for them when they couldn't get to school, how she brought groceries and food to school to feed them because of what their circumstances were at home, how she combed their hair when they came to school unkempt. That was the kind of person that she has been. She was a rising star in the Atlanta Public Schools, and it's unfortunate to see her here. I ask the court to sentence her based upon the totality of her life and not the limited life. My request for the court, as I mentioned on yesterday, was that she be sentenced to 5 years probation, that she be given the opportunity to enter this, that the court enter this sentence pursuant to the First Defender Act. This is what these kinds of cases, I think is what the First Defender Act is designed for a person to be able to make their recompense to society, to complete whatever instructions that the court gives them during that term of probation, and then to successfully go on with their lives. That's what we're asking the court to do here today. I'll keep it short.
All right. Ms. Jordan has how many charges?
Your Honor, she was only convicted of the RICO count.
Okay. So the recommendation is 5 to do 2.
Your Honor, the recommendation is 5 to do 2, a $5,000 fine, and $1,500 of community service.
Okay. 5 years to serve 2, balanced probated, 1,500 hours of community service, and a $5,000 fine. I'll sign an appeal bond for Ms. Jordan.
The order is there. First offender, Your Honor.
The state will object.
I'm not going to be able to do that.
I would only ask, Judge, that be something that the court seriously reconsider.
Okay, well, I don't know. Yesterday, I just said to everybody, this is the time to search your soul, and maybe we can end this. We can just end it, and the punishment wouldn't be so severe. But it was just taking responsibility, and nobody has taken any responsibility that I can see. And
ask one question.
I mean, but that was the time.
Judge, but why ask me one question, please? When you say to me, and I relate to my client, that you will do that you will give first offender under this kind of sentence, am I to take the court at its word? Am I to accept you that when you said that on yesterday morning, am I to accept it?
Well, yesterday morning was before I saw the light. I was trying to give everybody one more chance, and, probably going to have tomatoes thrown at me. But, nobody took it. Nobody took it. So You know, things change.
I know things
And
change.
all I want from any of these people is just to take some responsibility. But they refuse. They refuse. And
May I say
I
something
am
about that?
convinced that your client recruited those two retired teachers and cheated on that test. And this is where the whole thing came up. It was so outrageous, the scores on those kids from that school, that they came in, and that's what started the Atlanta newspapers. That's what started this whole thing rolling. And your client was there, and I'm convinced did it, but she...
As I'm sure that you're convinced that all of the defendants did. And I'm sure that you were convinced of that on yesterday, Judge.
So I didn't do anything. I mean, I don't want to, you know,
The only thing that you did to me, Judge, was that you promised me on yesterday that you would...
I didn't promise you.
You said that you would, and I accepted your word at that. And if I can't accept your word, the court's word at that, whose word can I accept?
Okay, well, I guess I'm just a... What do you call it, Emma? What's the word for me? Indian giver? I hope that's politically I was probably politically incorrect. But I'll consider it. I'll consider it.
Thank you, Judge.
Yeah, I'll consider it.
And the state continues their objection.
Okay.
Before we start, Judge, can I apologize on the record for raising my voice at the court? Just like yesterday, you apologized, and I sincerely apologize, Your Honor. You know, we've known each other for a long time. Will you accept my apology, please?
I will, reluctantly.
Thank you, Your Honor.
Okay.
I don't think he wants to hug me right now. Sure. All right.
Yes, sir.
Judge, on behalf of Ms. Buckland Webb. All right, so let me let you know, first of all, you heard some words yesterday about Ms. Buckland Webb. I told you about her background, what she's done over the past number of years, and you know, of course, that she has family who are present. I'd like everyone who is here for Ms. Buckland Webb to go ahead and stand, please, so the court can see that we have family, friends, colleagues who are here in support of her. Most of them over here to the court's right. Thank you very much. Judge, Ms. In thinking about what is an appropriate sentence for Ms. Buckland Webb, I simply have to think about her circumstances, this case, and to some extent other cases that I've dealt with previously. And when a court determines what is an appropriate sentence, it is actually quite simple. You know, we're here on the second day of sentencing, and it's been more convoluted than I think it needs to be. Ms. Buckland Webb has been convicted.
It's been way more convoluted than it needed to be from the start of this thing.
Well, Ms. Buckland Webb has been convicted, and what the jury found her guilty of was changing answers on students' tests. All right? Of her 53 years of living, she was convicted of doing something on one day in those 53 years. She was convicted of doing something in regards to tests for second graders that did not matter or did not count. I know I've said that before, I can't say it enough. She was convicted of changing test answers that whether she had changed them or not, it would have had no impact on what this whole trial has been about, AYP or targets. She was convicted of doing something at a school that did not meet targets, that did not meet AYP, that had absolutely no impact. They did not fail to get services or resources that they otherwise would have gotten. That is a truism. There's no dispute about that. All right? So that's what she's been convicted of. And so what I simply asked the court in starting my argument, or my discussion, is that you consider what is an appropriate sentence for a 53-year-old woman who has no record whatsoever, who is a mother, grandmother, wife, and everything else, what is an appropriate sentence for what she's been convicted of doing? I do not think that prison is an appropriate sentence. Maybe I've been doing this long enough, or too long, or other people have been doing it so long that prison doesn't seem like that big a deal. Well, it's a big deal, all right? Not just in terms of freedom, not just in terms of what happens in a prison, but who should go to prison? She ought not to go to prison. We've heard the phrase acceptance of responsibility tossed around. I will tell you that in my 23, 24 years of practicing law, as a prosecutor and as a defense lawyer, I have never had, for example, someone who has been convicted of murder stand in front of a judge, getting ready to be sentenced, but before they can be sentenced, they've got to say to the judge, Judge, I've been convicted of murder and I committed that murder.
Well, you don't have to. It's just
You
a life.
don't have to.
Well, it's a life sentence, no matter what you say.
You name it, aggravated assault, burglary, they don't have to do that, right? Because they've been convicted. She's already convicted. She's in front of you. She's going to be sentenced. So the only issue is what is the appropriate sentence. Now, I can tell you that we did not think it was appropriate. It was appropriate that she has to give up her appellate rights in order to get an appropriate sentence. That she has to stand here and say, I apologize to the judge in order to get an appropriate sentence.
It's not apologize to me,
Well,
it's
that's what was meant to
apologize to this whole community and these children. And she didn't cheat every child in this business, but she was a part of it.
Understand, Judge.
She was a part of it. I don't want an apology. I don't want it. I want the community to have the apology. And I want these children that were shortchanged and cheated to have the apology. That's the apology.
Understand that what I'm talking about, Judge, and I want to be very clear. What I'm talking about is when you urged us to have a conversation with the DA's office and they said, well, so take it or leave it and you got to give an apology to the judge as part of any deal that we're going to offer. We didn't think that was appropriate. We thought that was appropriate.
Is that part of it?
Yes, it was.
Your Honor, that, no.
How can you say that?
When we were asked to explain that, we said, if you're sincerely apologizing, just apologize to the court for your responsibility in all of this. And that was explained yesterday in detail. If there was some confusion, because there was questions and raised about what we were talking about with that phrase.
Your Honor, that is an absolute distortion of what we were told on Sunday and what we were told on yesterday. And I state that in my place as an officer of this court. That is a distortion.
Okay, would it make a difference if they didn't say judge, just apologize to the community?
But that's not the point. What I'm trying to convey to you, Judge.
Well, I don't know, it seemed to be the big point of this outrage.
We crafted and presented to the DA's office a joint statement from the defense.
Taking responsibility and apologizing to the community. We drafted a statement, and when they read it, they said, no, that's not going to go. No, that's not going to go.
They wanted to give us the words that we had to say to you. What we had to say and what we crafted with community leaders and with the DA and everyone else wasn't sufficient to them. They wanted the words put in our mouth, what we had to say to the court. And what I'm saying is that is what makes this thing so convoluted. That at the end of the day, Judge, what she's been convicted of, what is an appropriate sentence? And that's where we should be. Now, Ms. Buckner-Webb, if we're talking about acceptance of responsibility, and we wanted to stand before this court and say to the court that I accept and acknowledge that after hearing all of the evidence, a jury of my peers has found me guilty, that I'm remorseful for the turmoil and pain that this case has caused the children, the parents, and the rest of our community. I also acknowledge that there was evidence to support the jury verdict, that I could have been more vigilant in respecting and following the proper procedures of the testing process, apologize for any failure to act or commissions of unethical acts that tainted the testing process, intend to do our part and follow the court's direction in acting to rebuild and restore the educational process and system in the city of Atlanta. All right? That is what we were prepared to stand up in front of this court and say. And the reason
that doesn't quite get there. But go ahead.
Well, what I'm
It's more
trying
or
to...
less, I've been convicted, now I'm gonna just say that, I'm really not guilty, but, I accept the verdict and, I apologize. So anyway, go ahead.
Well, let me say this on Ms. Buckner-Webb's behalf, and I'm going to be measured in what I say because I represent her, and I want to make sure that her words speak through me, and they're not simply my words. When she was indicted, there were discussions with the state, and we felt as though there was a possibility of Ms. Buckner-Webb saying, I can take responsibility, enter a plea, but we were told, and there were representations made to us that, well, we're not going to, and the court is not going to consider any sort of offer plea. And that's where everything broke down. And so when you say, or when you look at us, or look at Ms. Buckner-Webb and feel as though she hasn't been willing to accept any responsibility.
Well, an offered plea does not accept responsibility. They just say, I'm in a bad place and I'm just doing this to, save myself.
And an offered plea is a guilty plea. It's a guilty plea.
But you deny the facts.
Judge, there are...
You don't take responsibility. You just say, I'm looking out for my hide and I don't agree with anything that's been charged.
What an offered plea says, respectfully, is that I believe that there may be evidence sufficient to convict me. I believe it is in my best interest to enter that plea. And that is done every day in this courtroom, other courtrooms, all throughout the state of Georgia. And it is recognized, it is legitimate, and there are legitimate reasons for doing that.
Well, Dorothy Hall came in and tried to do the same thing and refused to take any responsibility for anything that went on here. And I said, well, I will not accept an offered plea. You've got to be just like the rest of the people who were required to get up and take responsibility, say what they've done, and take responsibility for it. But she wouldn't do it. And a lot of people criticize me for not taking it. But, I think she needed to be just like everybody else. I knew she was sick. I felt sorry for her. But I would not take the offered plea for Dr. Hall.
I understand that, but Diane Buckner-Webb is not Beverly Hall.
Okay, I know that. I know that, and my sentence will reflect that.
My thinking, Judge, is that also...
I'm sorry, Judge, you don't understand. But the point is, we're not trying to argue with you about that. We just tried to point out to the court that we didn't even have the opportunity to consider that. Remember, that was the point that I made to the court yesterday. That we didn't even have the opportunity to have the discussion and consider that. And that's why I would make you upset when talking about being here and things like that. Because she didn't even have the opportunity to consider that, Judge. And that was the main sticking point. That's all. And thank you, Your Honor, for allowing me to say that.
One of the things that I asked you to consider yesterday, Judge, is that in regards to Ms. Buckner-Webb, the fact that she said, I'm going to plead not guilty and challenge the charges, does not mean that she doesn't care about the children. I wish you could see into Ms. Buckner-Webb's heart. I think I told you a bit yesterday about how much she cares for these children, how much she loves these children, and she's dedicated her life to teaching these children. I wish I could convey that to you such that it's not falling on deaf ears and that you understand. Ms. Buckner-Webb is a good woman, a good family woman, a good mother, a good person, and at the end of the day, a conviction for changing answers on a test is not an offense that should send Ms. Buckner-Webb to prison. I'm asking you, Judge, to consider sentencing her to somewhere in the area of 5 years probation. I'm asking you to sentence her as a first offender. No doubt you will give her a fine. She will not be able to get a job as a convicted felon, but first offender will allow her the ability to do that such that she can pay whatever fine the court imposes. I would ask you to grant an appeal bond, as you've indicated that you would if it's already presented as sitting on the bench. That's what I ask you on Ms. Buckner-Webb's behalf.
And so the state is clear, as to Ms. Buckner-Webb, the state does have no objection to first offender.
All right.
Ms. Buckner-Webb did not recruit anybody as other teachers did. She did not teach children terrible morals because the evidence was she did it by herself in a room with other educators, but she certainly did not corrupt the minds of children and teach them these terrible ethics.
Okay, well, what was the state's recommendation?
5 years to serve one with a $1,000 fine and 1,000 hours of community service. And we have absolutely no objection to first offender for Ms. Buckman with.
5 years to serve one, balance probated with 1,000 hours of community service, $1,000 fine, and first offender treatment. And Rhonda, have you written all these sentences already?
I'm writing down, but I can change.
But, okay. Well, anyway, I think all but the executive directors, you can let them, you can let the sentence be under the First Offender Act.
Thank you, Your Honor. And the order is before the court.
Thank you, Your Honor.
On the appellate board.
Judge, is there a compelling reason why the court is of the opinion that
Because I think there's differences in the responsibility, and these three ran the schools. How many schools are there? 58?
Yes, Your Honor. There was Mr. Pitts, 14 of his 15 schools.
Judge, and I know you made that decision, Judge, but I just want to clear up a fact. My client did not run the schools. My client's boss was Kathy Augustine, who's not here. And
Well, she should be here, but, maybe they didn't have the evidence on her. I don't know.
know that, Judge. All I'm suggesting to you is, when you make the decision that my client ran schools, my client ran 15 schools under the direction of someone else.
All right.
And I would hope that you would take some consideration of that. And
Well,
first offender is appropriate.
Your Honor, I would just add for Sharon Davis Williams, I respect the sentence that the court has given. I would just ask the court to consider that they are being distinguished and that each and every one of them are facing a 7-year sentence, which the court has found to be appropriate. I too would ask or renew my request for first offender to, again, allow...
Okay, I'll consider it. And a word about the unindicted co-conspirators and the hundreds of probably other folks out there that joined in this thing that were unable, the evidence was not, I guess, clear enough or strong enough to bring them in this indictment. But they're out there and they were involved. This thing was pervasive. It's like the sickest thing that's ever happened to this town. But let's go ahead.
And and they are facing a $25,000 bond. Hopefully they can become employed and pay that.
Okay.
Thank you.
Yes, sir.
Thank you, Judge Scott Smith and Ryan Walsh on behalf of Theresia Copeland. The state made a recommendation earlier of 5-1 based upon Theresia's involvement in this case, specifically that she did not recruit anybody, no involvement directly with children. The interesting part about her case, I think you remember, is that the principal for the school is an unindicted co-conspirator who now lives and resides in South Korea, but she wasn't indicted on the case. So I just want to take the court back and just, it's a difficult position. I think the court empathizes with our position in the sense that Sunday night we get a call, the recommendations for no jail time. Yesterday the court was kind enough to give us a break to say, hey, consider the state's offer, but it had additional conditions on it. That one, we waive her right to an appeal. Well, that would make sense if everybody did it. Everybody was not going to do that. So I had to meet with my client in the back and explain to her, well, you're waiving your right to an appeal, which means you don't have the ability to have an attorney review my work product. And it's tough for me to sit here and tell you, hey, in the next 12 hours, you should waive your right to an appeal. I can't advise you of that because I don't know, based upon 7 months of trial, what came up, what are issues that can be addressed by an attorney on appeal. So you can imagine it was a difficult position, right? But yesterday, before you sent us across the street or to speak...
It's not that difficult.
Well, it's difficult for me to advise a client...
Okay, well, I guess you advised her not to do that. Is that right?
Well, I told her that waiving an appellate right is a serious right that you have. And, you know, by giving that up, it's forever. You don't have anybody who's going to go back and look at this ever again and say, hey, Mr. Smith should have done X, Y, or Z.
Okay, I just wanted people to take responsibility and, you know,
Well-
was willing to, you know, not do what I planned to do.
Well,
And it was rejected, and now here we are, and, you know, I guess, are you gonna do the appeal?
No, Judge.
You're not?
Judge, I've spent money to be here handling this case.
Okay,
I
well,
think, you
is your
know,
client indigent?
I think she is, yes.
All right, well, I guess we need to get her a lawyer. We need to have a hearing about it.
And
Have the taxpayers pay for it.
And she would want somebody reviewing my work product as well. I mean,
Okay.
but you bring up a good point. Yesterday, before we went and spoke to the district attorney, I stood up on behalf of 3C Copeland and accepted responsibility. I mean, we could read it back in the transcript, Ms. Evelyn took it down. I stood up here and accepted responsibility. So with
Well,
that,
did she whole scale changed all those?
We appreciate you joining us here for the sentencing phase of the APS test cheating trial. Stay with us. We will reestablish our connection here momentarily as more sentences are expected to be handed down in just a few moments. We apologize for the signal issues there that we had inside the courtroom, but we'll get our signal established here momentarily and bring you more continuing live coverage here on Fox 5 Live. Stay with us. We appreciate you standing by with us as we work to reestablish our connection there from the courtroom. Having some signal difficulties there from the feed, but we will return to the courtroom here in just a moment. So let's review some of the sentences that we have been hearing here, including Donald Bullock, weekend in jail for 6 months, a $5,000 fine, 5 years of probation, 1,500 hours of community service. Sharon Davis Williams, 20 years, 7 to serve, $25,000 fine, 2,000 hours of community service for her. Tamara Cotman, 20 years in prison, 7 to serve, $25,000 fine, and 2,000 hours of community service. Michael Pitts, 20 years in prison, 7 to serve, $25,000 fine, and 2,000 hours of community service. Those are some of the verdicts that have been handed down thus far. Dana Evans, 5 years in prison, 1 to serve, 1,000 hours of community service. Angela Williamson, 5 in prison, 2 to serve, $5,000 fine, 1,500 hours of community service. And Tabika Jordan, 5 years in prison, 2 to serve, $5,000 fine, and 1,500 hours of community service. So earlier, those were some of the sentences that were handed down in this particular case. We do expect to rejoin our live feed here momentarily. We appreciate you bearing with us here as we reestablish our connection in the courtroom. You're watching live continuing breaking news coverage on Fox 5 Live.
To address indigency, we need to address, and I think I already have, the record, the production of the record, which Mr. Davis, I guess we're going to have the county pay for that. Is that right?
Just the one transcript and the record, which we pay for everybody. Of course, I'll be not asking for any attorney fees. Yes.
Okay, so
Ms. Cotman, we're all set for you.
but everybody needs, in the meantime, to discuss who the appellate counsel will be, if there needs to be substitution of counsel, and if not, whether appellate counsel need to be appointed, because we need to get those folks over to the public defender's office. What do you call that, Rhonda? Yes. All right. Will be, and I'll sign these appellate bonds.
I think some of them are already before the court.
Has everybody got them here, in here?
It was just emailed.
Just email it, okay, all right.
Judge, I guess before you, have you contemplated and considered as far as questions on this position?
Yeah, I'm gonna give everybody first offender, which means if they screw up on this, that you need to have an auditor that this community service is done.
Yes.
I mean, I don't want any of this 5-for-1 deal at the church or wherever. This has got to be done, and it's got to be done to help the prisoners or help the children in this community, the community service.
Yes, Your Honor.
These are capable people that can teach, and so I'd like that to be their community service.
Your Honor, the state would ask that you have now given everyone first offender. If you need, we would ask that you go on the record and tell them the benefits of first offender as well as the downfall.
If you don't do what you're supposed to do, or break the law, they can bring you back to me. I can re-sentence you just like we were starting all over, and there's no trial and there's no nothing. There's just a hearing, and I can re-sentence you. If you do complete this probation and you do all the conditions, do all the community service, then you will not have a felony on your record.
Thank you, Judge. On behalf of the commission, we appreciate your
Okay.
considering that.
The same one, Ms. Williams.
Yeah,
Thank you, Your Honor.
okay. All right.
Everybody, I need everybody to leave out this door. Everybody to exit this door.
Do you have any of those?
Yeah, I guess.
And with that, we have seen this sentencing handed down for at least 10 of the individuals today in the APS test cheating trial. It has been certainly at times a very tense courtroom, not only throughout the trial, but throughout this sentencing phase as well. To join us for continuing coverage of the verdicts, to help understand everything that was handed down, or the sentences rather, the sentences in this case, to get a larger picture of the sentences, we invite you to visit myfoxatlanta.com. We do have a list there of all the defendants and the sentences that they were given, as well as a photo gallery from moments today. And you can also watch a replay of this entire live stream if there are any moments that you miss and you would like to review. So that coverage is available for you now on myfoxatlanta.com. We also have continuing coverage on our Twitter feed as well, at Fox5Atlanta. We appreciate you joining us for this developing news live coverage of the sentencing phase of the APS test cheating trial. You've been watching Breaking News coverage on Fox 5 Live.